started. Thank you. Good morning, everyone. Thank you for being here. It's so wonderful to see so many familiar names on the program and familiar faces in this room. This is a fascinating and timely symposium, and made even more so by the extraordinary panelists that we have today. So today's event features 3 distinguished panels and a lunchtime speaker, as you know. And it's really going to explore this complex tension between citizenship, security, and civil liberties in our post-9/11 world. In particular, 3 interrelated themes will shine through today. How have the post-9/11 legal and policy battles affected the legal rights of citizens and non-citizens? How can we best understand the tensions between the state's duty to protect its citizens and its desires to protect individual rights and liberties? And then finally, has the vigilance about terrorism weakened the protections associated with U.S. citizenship, particularly with respect to ethnic and religious minorities? So this discussion will be brought to life today by, as I said, a tremendous lineup of scholars, commentators, and experts, some of whom have traveled far and wide to be here. And so, once again, I extend my sincerest gratitude to each of the panelists today for your contributions to the conversation. I would also like to thank our 2 hardworking co-hosts, the Center on National Security at Fordham Law and Fordham Law Review, for their coordination, vision, and excellent work behind the scenes. In particular, I want to point out Karen Greenberg and Susan Quattrone, who I know is in the room, from the Center on National Security. As many of you know, the Center on National Security is an integral part of our community now and a vital resource for the 21st century national security issues for scholars, policymakers, and businesses across the country. We're exceptionally proud to have Karen Greenberg associated with Fordham Law School. Secondly, Alex Wolf of the Fordham Law Review. Fordham is our flagship law review, as you know. It's the 5th cited, or the 5th most cited law review in the country, and the 10th most cited law review in court decisions. So I very much look forward to the upcoming issue that features this symposium, and will capture the rich discussion that we'll have today. And so finally, I'm exceptionally proud of Joe Landau and Andrew Kent, of our own faculty, who provide the scholarly leadership in the field, and who, together with Karen, have made Fordham a real leader on national security issues. So once again, welcome on behalf of the Dean and myself. I hope that you enjoy the critical reflection and discourse that comes with today's symposium. I know that I will. And at this point, I'm going to turn the program over to Karen Greenberg, who will moderate our first panel.
Thank you, Sheila, and thank you all for getting here so nice and early. And I just want to reiterate the thanks to the students who put this together, because from my point of view, this was like effortless. So that must have mean you did a lot of amazing work. So thank you. I want to just preface this panel, which I think will be rather provocative, with a few remarks about how we got to the notion, or to the question of, has the notion of citizenship changed since 9/11? Because what's happened, I think, in the overall debate, scholarly and otherwise, on the post-9/11 legal world, is that most of us have been in a reactive mode. Every day there's some headline, some policy, some discussion, some debate in Congress, some activity abroad that happens that we have to react to. And the problem with reacting like that is that it's very hard to step back and think. And you know, those of you who come often, that the center often tries to figure out what the buzz beneath the headline is. You know, I think one thing that hasn't been sufficiently attended to is the notion of citizenship. What has happened to the rights of non-citizens? What has happened to the rights of citizens? Is there some kind of separation of the categories in a greater way than there was before? Is there a reduction of rights for American citizens so that they don't have to be extended to non-citizens in certain contexts? And the interesting thing about this topic is that if you scratch the surface of it and ask the people who we've assembled here today, who have been cutting-edge thinkers on the larger issues related to detention and torture and targeted killing, you'll find that immediately they know that there's been something to think about and something worth talking about. So we put together this panel to introduce today's topic. We will be talking as well about immigration and other issues, but perhaps the shift began within the context of the war on terror. So let me introduce to you our panel, and then we will hear from them, and then there will be time for Q&A from you. I think you've seen many of our panelists before at our events, but let me just give you brief introductions. Azmy, legal director of the Center on Constitutional Rights, has been involved in numerous issues related to the war on terror, particularly to Guantanamo. He's well known as an expert on civil liberties and human rights. He did the clinic at Seton Hall on civil liberties, human rights, and national security. And he's one of the voices that everybody goes to figure out what we should be thinking if we're well-being constitutional lawyers. Next, we have David Cole from Georgetown University Law Center. David is most known, I think, for his writings in the New York Review of Books on various topics related to the war on terror and to legal constitutionalism in general. He has 2 books I want to bring to your attention, Enemy Aliens and the Torture Memos, which speak directly to the 9/11 context. And he's working on a new book, which it sounds pretty fascinating, which is on the role, I won't get this right, but just take it from me, it's sort of about this, the role of the NGO community and how important it is in actually either stopping the country from going in a certain direction or enabling the country to evolve in a new direction and sort of an unappreciated piece of the puzzle. Tom Lee is the Leitner Family Professor of International Law here at Fordham Law. He is a prolific writer, both on international and on constitutional law. And I think in recent months, his deep expertise or personal expertise has become particularly interesting because he's a formal signals intelligence officer with the Navy. So if you have any questions at the break about NSA, I suggest that you just get on him. Peter Margulies, professor of law at Roger Williams University School of Law. He's the author, for these purposes, of Law's Detour, Justice Displaced in the Bush administration. And he's recently been writing about immigration law, so he's a good bridge between how we think about citizenship in terms of the war on terror, national security, and how we think about it in terms of the national security issues of immigration. And finally, Michael Paulsen, University Chair, Professor of Law at St. Thomas School of Law. He has 2 rather distinguished books on the Constitution, and he has a number of books that look at a wide array of issues about constitutional law. So what I would say about Mike is that you never know what direction he's going to go in next. And having said that, this panel is going to cover more territory than you can possibly imagine. And we're going to start with Michael, who is going to talk a little bit about sort of the historical precedents to the notions of citizenship in times of duress, war, and national security being threatened.
Well, thank you, Karen, and thank you to the Fordham Law School, to the Fordham Law Review, and to the Center on National Security Law. It's really an honor and pleasure to be here. I think given how many of us there are, I'm supposed to keep this to 10 minutes. So stop me if I go longer than 10 minutes.
I'll stop.
There's Professor Itis in this. And similarly, Professor Itis, I passed around, I don't know if there were enough copies, a handout, just so you can have something to don't worry, there won't be a test on this. But I'm going to be reporting on a historical incident. I'm going to report on an incident of the proposed use of lethal force by unilateral order of the President against U.S. citizens who are non-combatants. In order to kill captured U.S. citizen enemy combatants who are held as prisoners of war. It's shocking. My title is With Malice Toward Some, Lincoln's Order of Retaliation. About 150 years late, I'm not really reporting on the issues of war on terror after 9/11. I'm reporting on something that happened 150 years ago this past summer. And what happened this summer was Lincoln issued possibly his most shocking, extreme order as president, as commander-in-chief. He authorized the intentional killing of captured, surrendered Confederate POWs, Confederate soldiers in Union custody, who had not committed any offense against the laws or customs of war. So, by definition, these men were what we would regard today as non-combatants. They're prisoners who laid down their arms, and they were being held as prisoners. Lincoln authorized their killing. Some might say murder, as explicit act of retaliation for Confederate atrocities against black Union soldiers conducted as a matter of official Confederate policy. As I'll explain in a second, they declared a Confederate policy toward black Union prisoners was to take no prisoners and to either re-enslave them or execute them as essentially war criminals or as a slave uprising. And I hope this will be a good way of introducing some of the modern discussions, because in some ways, Lincoln's order of retaliation is a paradigm case, an interesting parable about all sorts of issues of war, morality, retaliation. If you're into constitutional law, as I am, it provides perhaps a window for thinking about issues of constitutional power, the allocation of those powers between the president and Congress in times of war. So in my remaining 9 minutes, I'm going to just sketch out the facts of the story, say a little bit about the law, and then raise some questions about morality. Facts. Okay, let me first set the scene. As most of you know, or you really should know if you had a decent high school or college education, in 1862, about a year and a half into the Civil War, Lincoln settles on a policy of emancipating slaves. Initially, he had resisted that for practical, tactical, military, political, strategic reasons. But eventually, in the summer of 1862, Lincoln thinks that as a necessary war measure, and pursuant to his powers as commander-in-chief, he wishes to issue an order of emancipation, the Emancipation Proclamation. He has to wait for a while because Secretary of State Seward convinces him that it would be improper to order it at a time when the Union appears to be in retreat. So let's wait for a victory. Lincoln says that's a good plan. They wait for a victory, and he prays for a victory. He actually makes a promise to God that if the Union wins Antietam, he will issue this Emancipation Proclamation. And in September of 1862, he issues what's called the Preliminary Emancipation Proclamation, declaring all slaves in Confederate-controlled territory, in enemy-controlled territory, to be free. Basically, he will seize them as enemy material and confiscate them and transfer them to Union. He goes through with that. He issues it first as a 100-day warning, right? If you return to the Union, we won't do this. And then on January 1st, 1863, he issues the final Emancipation Proclamation. And along with it, he includes a command that the freed slaves will be accepted into Union ranks as soldiers and sailors. Okay? So it's not just an order of emancipation, which is of enormous consequence in its own right, a very audacious, but not at all unprecedented, invocation of the law of war by the president as commander-in-chief to free enemies, free slaves held in enemy territory. But going beyond that, perhaps the most audacious thing yet, at least at the time, was that the freed slaves would become Union soldiers. This drove the South absolutely bananas. From the Southern ideological point of view, that is taking their slaves and fomenting a slave insurrection, which under the domestic laws of the Southern states was basically a murderous act. Basically, you are criminals. The reaction of the South was fast and furious. Jefferson Davis very quickly said that this was a war crime, an atrocity, the most, let's see if I can pronounce it, execrable act that could possibly be committed to use the slaves, their slaves, against them. And it became very quickly the Confederate official policy that black Union soldiers would not be treated as prisoners of war. Take no prisoners, no quarter, you need not be burdened with this. Some of the statements of the Confederate Secretary of State, James said, or Secretary of War, just truly outrageous. said we need not be burdened with them, rather we should not be inconvenienced, but they should be executed if captured or be enslaved. This presented a practical problem requiring a response from the Lincoln administration. And the response eventually became what I have given you there as the Order of Retaliation in July 1863. And let me just read it for you because I know the handouts didn't go all the way around. It's just 3 paragraphs. Here's Lincoln's order. It is the duty of every government to give protection to its citizens of whatever class, color, or condition, and especially to those who are duly organized as soldiers in the public service. The law of nations and the usages and customs of war as carried on by civilized powers permit no distinction as to color in the treatment of prisoners of war as public enemies. To sell or enslave any captured person on account of his color, and for no offense against the laws of war, is a relapse into barbarism and a crime against the civilization of the age. The government of the United States will give the same protection to all its citizens, and if the enemy shall sell or enslave anyone because of his color, the offense shall be punished by retaliation upon the enemy's prisoners in our possession. Here's the punishment. It is therefore ordered that for every soldier of the United States killed in violation of the laws of war, a rebel soldier shall be executed. And for everyone enslaved by the enemy or sold into slavery, a rebel soldier shall be placed at hard labor on the public works, and continued at such labor until the other shall be released and receive the treatment due to a prisoner of war. Now, to give away the end of my story, Lincoln never executed any captured POWs. Okay? But he was sorely tested on a number of occasions because it quickly became the Confederate practice to execute black prisoners, and there were demonstrable massacres that occurred. The most notorious was one at Fort Pillow in 1864, about 9 months later. Confederate General Nathan Bedford Forrest massacred clearly about 300 black Union soldiers who had laid down their arms. Now this presented President Lincoln with a bit of a problem, because if you draw a red line, you have to respond. And he received much urging from, among others, Frederick Douglass, that you should go ahead with this. This is necessary to protect our soldiers from massacre by the enemy. That the only way to deter and prevent further war crimes is to commit what otherwise would be regarded as itself an atrocity. Lincoln convened a cabinet, and they took, cabinets are wonderfully helpful things. They split 4 to 4 on the question of what to do, with some saying, that the morally right thing is to go forward with the execution. Others saying, look, this will just produce a cycle of violence and atrocity. There's really nothing to be gained from it. What Lincoln ended up doing, classic Lincoln deftness, was he issued an order in May of 1864 to be communicated to the South through official channels, that they would identify 300 Confederate POWs, officers, all officers, not enlisted, by name, and set them aside as hostages. He said, if there are no further atrocities, and if you issue a commitment to treat them as prisoners of war, they will be returned to their regular status. Now, it's classic Lincoln not to say the next line, what if you don't? But the implicit threat there is that he will go forward with this order of retaliation and execute prisoners. Now, in the end, this is overtaken by events. There's no clear historical evidence that the South responded, certainly not officially, but there were further atrocities committed. But basically, the events of the war overtook this, and Lincoln never did have occasion to follow through on it. Meantime, the real consequence was because the South refused to treat black soldiers as prisoners of war, and they did hold some black Union soldiers. Prisoner exchanges between the two sides broke down. The South was prepared to continue the policy and practice of prisoner exchanges, but of whites only. Lincoln declined to do so, with the consequence that there became suddenly, late in the war, enormous thousands of numbers of people who were held as prisoners of war on both sides in atrocious conditions. Andersonville prison in Georgia, nearly 13,000, I believe, Union soldiers perished. During some of the late battles in 1864 and early 1865, Grant offered to exchange prisoners with Lee. Lee agreed, but then Lee said, "Oh, but not capture blacks." And Grant said, "Well, we're done then." Eventually, in desperation, the South issues its own policy of emancipation of blacks in order to have them serve in the Confederate Army. It never actually occurs, but it's only in 1865 that prisoner exchanges occur. Okay, that's the facts. I've used it to take up a long time. But I think it's an interesting parable, an interesting story, and there are interesting lessons possibly for today. In terms of the law, the question beyond the constitutional law guy, the question that occurs to me is, was the Emancipation Proclamation constitutional? And then the second question is, was the order of retaliation constitutional? My view, and I've set this forth in other writing, is that the Emancipation Proclamation was constitutional as an exercise by the President of his commander-in-chief power in time of war. This was Lincoln's rationale, as he explained on several occasions. He believed that the Constitution vests the commander-in-chief with the power of war during time of war, including the use of the law of war. The law of war traditionally had said that you can seize enemy property and confiscate it, including slaves, and he was invoking that, the law of war, offensively as a weapon. Another lesson I tend to draw from this is that policies toward captured persons, including U.S. citizens, fall in time of war within the commander-in-chief power of the president. Now, you can think that presidents sometimes misuse or abuse that power, but as a constitutional power, the decision as to what to do with enemy prisoners, detention, capture, interrogation, military tribunal punishments, is, I think, properly a commander-in-chief power of the president and not a power of Congress. So that the answer, as a matter of constitutional law, was the order of retaliation constitutional? I think the correct conclusion is that it lay within the commander-in-chief power of the president to make that determination one way or another. Similarly, that the power to interpret and apply the laws of war in the theaters of war is a power of the president. I'm going to skip down finally just to the question of morality. Just sort of pose it out there. It might be something for discussion if any question and answer here. Was Lincoln's order of retaliation morally justified? Was his failure to carry out executions, in some sense, a failure of will and a moral failing in that sense? My own view is somewhat conflicted and ambiguous. I think that Lincoln, to his great credit, issued this order of retaliation as a necessary imperative to protect his African-American Union troops from being slaughtered, and that it was an imperative moral duty of him to do so. At the same time, I think it's also to Lincoln's great credit that he did not execute otherwise innocent Confederate prisoners of war in retaliation. In the end, he did it on practical grounds, as he explained to Frederick Douglass. If we do this, all it will do is produce a cycle of retaliation. There are Union soldiers in Confederate custody, and they will be killed too. Now, it's always perilous and sometimes trite to draw lessons from history because, though history doesn't repeat itself, it does have a fondness for certain repeated themes now. And I hope that in the discussions today, we'll think of this as like a parable and an interesting test case through which to view many of today's issues. Because if you think Lincoln's order was morally and or legally right, then a lot of the difficult questions we face today become comparatively easy.
Thank you for letting us know that the president is so easy. Just one, one thing I just want to say, and then we're going to move on to Tom, which is, you know, I guess there's also the possibility that he issued this order of retaliation knowing at the time he was just issuing it and not going to have it enact. And that it took a certain amount of political pressure off. Just in terms of today's context, I thought I would mention that. So now, because it turns out that history always can be disappointing, Tom is going to tell us how it's less disappointing.
No, I have a happier story about the history if you are pro or more peaceful measures. And the story I'm going to tell is about what I call the treasonous Citizens' Bill of Rights. So how many of you have heard of the Bill of Rights, the presumptively loyal Citizens' Bill of Rights? Everyone, right? How many of you heard of the American treasonous Citizens' Bill of Rights? I don't think anyone has, right? But we do have one, and in fact, it has 4 key provisions. It's got 2 things called the Bill of Attainder clauses, one against the federal government, one against the states. It also has something called protection against ex post facto laws. It also has the treason clause in Article 3 of the Constitution, which specifies that there has to be certain proofs before you can prosecute someone for treason, and then limits the punishments that can be imposed for treason. Right? So my argument today is going to be about how the Bill of Attainder, the Federal Bill of Attainder clause, I believe, constrains Congress and the President's ability to use targeted drone killing of U.S. citizens, even in wartime, even abroad. And that's one of the arguments that was made in the ACLU's case against the government officials for the Lockheed killings, but it really hasn't been picked up very much in the literature. And so I just wanted to walk through this and to explain why I think it has some traction. Right? So, and I'm going to begin with the history of the protections. And so you know, the Bill of Attainder protection, it says that Congress shall not pass a Bill of Attainder. What is this? It was a measure originally passed by British kings and even pretender kings in the 14th century, saying that X is an enemy and shall be executed, and all their property shall be forfeit, and their heirs shall also be executed, and so forth. So it was an attempt of monarchs to essentially destroy their political enemies who they accused of treason without having to bother with any judicial process. Right? So as British practice, as Parliament became more powerful, the principle that the king could do this unilaterally had essentially evaporated. And so by the time the Americans came on the scene, it was pretty clear that under English legal history, they needed Parliament to sign off on a Bill of Attainder. There's no, the British don't have a written constitution, but as late as the Second World War, there were still those who believed that England could, the authorities could use these things. So what exactly, but in the U.S. Constitution, they repeatedly outlawed these things. And they repeatedly outlawed these things for 2 reasons. One was the framers themselves were arguably treasonous subjects. Right? So it was sort of a self-validation proposition for them. Now, the second problem was the colonists had actually used their own Bill of Attainders during the War of Revolution, most famously in New York against a man named Wickham, and in Virginia against loyalist rebels. And in fact, Jefferson wrote the Virginia Bill of Attainder. So, but by the time they had gotten to the Constitution, they had a different problem, which was they had signed the Treaty of Peace with Britain, and some of the Treaty of Peace provisions required the different states and the United States collectively to return loyalist properties that had been taken and confiscated, and to essentially allow debts to be paid, to resume commerce and so forth, relations with England, because British commerce was essential to the survival of the Republic. They had been sort of nurtured under the British colonial preference regime, and without it, until they could develop trade with other parts of the world, they were in very bad shape. Right? So there were very important reasons why they wanted to prescribe Bills of Attainder. So let's fast forward a bit. So the protections are written into the Constitution. And in modern history, they sort of lay dormant. They came alive again during the Confederacy. and then again during the Cold War stares. And then I'll describe in a moment what the doctrine of bill of attainder is. And then finally, starting in 1996 or so, started by Larry Tribe, very creative constitutional law scholar, started using the bill of attainder protections to litigate against economic litigation targeting big companies like the telephone companies, the public utilities, the big banks, saying that, well, you're naming baby bell companies or big banks and so forth, and you're enacting this punitive regulation which amounts to punishment, and so therefore you're enacting bills of attainder. So this is the new generation of bill of attainder challenges that's been out there. So what does it take to be a prescribed bill of attainder? It has three elements. One is the legislature can't name somebody and punish them. It's very simple. The legislature cannot name and punish someone. Right? So let's think about targeted drone killing. Punishment, a lot of times in bill of attainder cases, punishment is where a lot of the action is, because there are things like restraint of business, or you can't have certain kinds of jobs, or so forth if you're a communist. And so there was a lot of action about punishment. Not an issue here. You're dead. Right? So punishment is not to be litigated. Naming. Once again, there's some litigation on that, and the doctrine essentially says you can't get around the naming. So obviously, if you name Richard Nixon or Lockwood, that's a naming. But what happened was sometimes there's legislation that uses purposefully vague languages, general language, to get around to a class of one. And the cases said you can't game it that way. If everyone, if an objective person can read it and figure out who you're talking about, then that's still naming. Right? So it seems if, and we don't know for sure, if somewhere in the chain of custody there is a document naming ex-U.S. citizen to be targeted by a U.S. drone strike, then that satisfies the naming requirement. So that leaves the legislative requirement. And the legislative requirement is interesting because if you recall back to my history, the fact that the legislative restrictions written into the provision is only an accident of when the restriction came. Because essentially, even though in the 14th century, British kings and pretenders and queens had actually used them unilaterally, roughly by the 17th century, that practice had essentially ended. So it seems to me, one argument we could make is, well, we don't have to be formalists here. It says bill of attainder, and it targets the legislator, but clearly that means the president can't do it on their own, correct? That's one argument. Now, another argument that I think you could make is, well, when the president is doing these things, he's not claiming unilateral authority. You're claiming authority by declaration of war or the authorization of the use of military force. There's some congressional statute in the background that is enabling this. And then could the argument possibly be made that even though that statute is purposely vague and doesn't specify the name, if it delegates a power, if it delegates broad powers, and among those powers is the ability to name and kill somebody who's a U.S. citizen, then that too is a bill of attainder. That's a plausible argument in my view, right? I mean, it's arguable, but it seems to me that Congress shouldn't be able to get around this by delegating to the president and then allowing the president to use naming. Now, if you think about it, I think the best argument against the bill of attainder provision, and my colleague Andrew Kent and I have talked about this quite a bit, is that, when President Obama puts a U.S. citizen on a kill list, he is making a call as commander-in-chief in wartime. And he can make operational decisions permitted by the international laws of war. This is sort of ties into Michael's point, although I should add that under the present laws of war, the doctrine of retaliation has been retired for a while. Right? So you can't do that anymore. You used to be able to do it. And the puzzle that he sort of laid out there actually had its first antecedent during the Revolutionary War. When George Washington, what happened was it actually happened 10 miles from here. A loyalist commando team went over to the American side over in Fort Lee and kidnapped an American soldier and executed him. And so Washington held a lottery of the English officers that he was holding. One actually very well-connected gentleman, English gentleman, had been picked, and they were getting ready to kill him. And they negotiated back and forth. The letters are very interesting to read because Washington is little bit weaselly and very apologetic about having to do this and never ends up doing it. So the argument is it's war, the president has commander-in-chief powers and he's permitted to do that in wartime. And I actually think that that's a pretty strong argument. And the way I deal with that argument is I'm going to construct 3 hypotheticals for you, right? And they're sort of loosely based on reality. So, one, you know, as I mentioned, Winston Churchill, during the Second World War, according to Alan Brooks' diaries, his military chief, wanted to issue summary execution orders for all the Nazi leaders and line them up and shoot them as soon as the war ended. But all of his advisors said, well, if you want to do that, you have to have Parliament issue an act of attainder. And plus, the Americans certainly won't go with that. And actually, the Soviets think that's a little bit harsh, too. So maybe you should reconsider this policy, right? So he backed off, right? They weren't even British subjects, so that's not the hypothetical. That's an interesting anecdote from a sort of cousin legal tradition. So these are hypotheticals. Imagine Lincoln issues this order. Captain Kent, you will take a squadron of cavalry, proceed into the so-called Confederate States of America, and kill until he is dead Jefferson Davis for treason against the United States and other crimes, right? So I actually think that would have been unconstitutional. It wasn't even contemplated. Now notice if he had issued this order instead. Captain Kent, you will take a squadron of cavalry, proceed into the so-called Confederate States of America to capture Jefferson Davis and bring him to justice for treason against the United States. You are hereby authorized to use deadly force if he attempts to evade or escape capture. Right? That would be okay. Second hypothetical. FDR, Franklin Delano Roosevelt, in the Second World War, ordered the shoot down of Admiral Yamamoto, the Navy cryptologist actually, so I can sort of claim some credit for that by institutional affiliation, had broken the Japanese naval codes and knew that he was flying up to do an inspection. And so they sent a squadron of fighters and they shot him down. Actually, Justice Stevens, he wasn't a cryptologist, he was a watch officer. And you know, I've talked about this because he was a watch officer when they sent out the kill order for Yamamoto. So let's assume that Yamamoto was actually a U.S. citizen, right? He actually had spent a lot of time in the United States. Like a typical sailor, he liked drink, women, cars, and so he liked the United States during his visit here in the 2030s. I actually think that that's really tough, but I think that that's okay, right? Because even though he's a U.S. citizen, he is sort of a tactical commander in the lines engaging in actual supervision of troops, right? So the third hypothetical. There is someone called Lord Haw Haw. How many of you know who Lord Haw Haw was? William Joyce. Lord Haw Haw. Yeah, so Lord Haw Haw was a notorious English collaborator. He had been a British Nazi affiliated with Mosley and his people. And when the war happened, he went to Berlin and he broadcast these obnoxious, you will die, why don't you surrender, Hitler is your friend, kind of things over and over again, right? So let's assume that Lord Haw Haw was Lord Hee Haw, and it was actually an American, right? And so let's say FDR issues a kill order to kill Lord Hee Haw, right? So I actually think that is for treason against the United States. I actually think that would be an unconstitutional rule of attainder. Now what did the British actually do? They waited, they captured him. Some people really did want to kill him, although by the end of the war he was a running joke, right? And then after the war, they brought him to the Old Bailey, they tried him, and they killed him then, right? So in any event, my story here, and I'm going to publish an article about this in the Fordham Law Review, but it's sort of an interesting argument about the Bill of Attainder and how it's presently applicable to these protocols.
I'm not sure that was more optimistic. That Bill of Attainder as a justification for the, I don't know about that. So anyway, maybe one of our other panelists will save us. We're going to turn to Peter Margulies, who's going to talk a little more generally, I think, about a whole range of topics that have, from international issues to domestic issues, that have brought to light the citizen issue. Warren.
Thanks, Karen. What we learned from the recent New York mayoral race is that the biggest existential divide in the universe is between Manhattan and the boroughs. I'm a native of the Bronx, so I guess I'm speaking here in my capacity as a guest worker. But I want to talk to you more broadly about citizenship and conceptions of citizenship. And to do that, I'll go back to the founding era. Conceptions of citizenship can yield great benefits for the people who receive them. My father, for example, is a Holocaust refugee. He was very honored to become a U.S. citizen. It's the same thing with my mom. But in addition to those benefits, citizenship brings burdens, including the risk of criminal prosecution, and sometimes, to reiterate the theme we pursued thus far, the risk of death. So to that extent, I'll be grim in the fashion of our previous panels. In the founding era, there are two strands, one of which is what I call the affective strand of citizenship. That is the notion that citizenship is an emblem of solidarity, as Michael Walzer says. It's a sense of belonging you have to a community, a sense of special regard that your fellow citizens have for you, and then officials of the state in which you are a citizen want to have for you. We have one bringing example of that from the founding era. It's an interesting case involving the mutineer Thomas Nash, who was extradited to Britain by President John Adams. Nash had mutinied on a ship that was known for the gross abuses of its captain. He was a captain of the British Navy, which was guilty of widespread brutality at that time. And Adams had signed a treaty with Britain, and he felt he was following the treaty. There was one wrinkle in this otherwise handy scenario, though, and that is that Nash claimed during the extradition proceedings that he was not Thomas Nash, but in fact he was Jonathan Robbins, a Connecticut-born U.S. citizen. And as a result, Nash said he couldn't be extradited to Britain. Adams really didn't pay a lot of attention to the citizenship claim made by Robbins/Nash, which may have been actually an ersatz, a phony claim. But the result of that failure to pay due regard to Nash's citizenship claim had disastrous results for Adams. That was perhaps the biggest single incident leading to his failure to gain re-election at the election of Thomas Jefferson in the election of 1800. In addition, it set extradition back in this country well over 40 years. We had no extradition to speak of because of the firestorm that erupted over the presumption that you could take someone who even claimed to be, perhaps falsely claimed to be a citizen, and deliver that into the hands of another nation. And Britain, as you might imagine, didn't really treat mutineers that well. Nash was summarily tried and then executed in a way reminiscent of Lord Hall, in the way that Tom described. So that affective notion of citizenship is very, very important. We see that through the present day. So when President Obama promulgated his program called the DAPA program, Deferred Action for Childhood Arrivals, he talked about children came to this country in circumstances beyond their control, because their folks came here. They all had undocumented status. But those kids were, for all practical purposes, President Obama said, raised as Americans. They really belong to our community. And the attempt to regularize their status, at least stave off removal, deportation for those folks, is something that Obama linked to notions of citizenship and belonging in our republic. There's another strand, though, from the founding era. That's a strand that Professor Flaherty has written about a lot, and I call it the membership strand, the notion that America is a member of the community of nations, and that American citizens, therefore, incur special duties as a result of that membership. The case in point there is the Neutrality Proclamation that President Washington enacted that made sure that we stayed out of the burgeoning conflict between Britain and France. That included not just a statement of U.S. policy, it also included duties that were imposed on U.S. citizens on pain of criminal prosecution. And in Henfield's case, well-known case of that era, you had John Jay and James Wilson who said that neutrality had to be enforced by constraints on private citizens. and citizens who disregarded the Neutrality Proclamation could be prosecuted. Let's bring this up to the present day and see how these different strands, the affective strand and the membership strand, have fared since 9/11. So one example is the cases involving damages for people who've been deprived of liberty or subjected to coercion by U.S. officials in the war on terror. That includes U.S. citizens. Take the case of Vance v. Rumsfeld. In that case, you had a U.S. citizen who was a military contractor in Iraq. He was detained and subject to what pretty much anyone would call torture. It turned out to be completely innocent. He was charged with giving aid or giving arms, actually, to folks who were fighting the U.S. It turned out to be without basis. He was eventually released. He sought a remedy for the suffering that he endured. The court ruled, the Seventh Circuit ruled, opinion by Judge Easterbrook, that Secretary Rumsfeld basically couldn't be bothered with ascertaining the citizenship status of folks that we had detained in Iraq. And as a result, a damages action under the doctrine of Bivens wouldn't lie. That to me is really an appalling decision. To say that a cabinet secretary, a senior U.S. official, has no interest in due regard for the status of Americans who are held by us abroad, to me shows a complete lack of consideration for the affective dimension of membership and citizenship status, that we owe some duty. Attention must be paid, as Arthur Miller said in his great play, Death of a Salesman. So damages actions, I think, are kind of a nadir, a low point of how the affective strand has been treated after 9/11. But there's another strand, the membership strand. How is that fair? There, I think I have a somewhat different view, perhaps, than other people on the panel. So there, one thing we've seen is that American citizens do have duties vis-a-vis the world. Case in point is the so-called material support statute, which says you can provide support, including funding, to designated foreign terrorist groups, which include Hamas or Al-Qaeda. The Supreme Court had a leading case on that, the Holder versus Humanitarian Law Project case. David Cole, my illustrious co-panelist, was the person who argued for the petitioner in that case. The person who argued for the government was none other than Justice Kagan, who then was Solicitor General. In that case, Chief Justice Roberts, writing for the majority, talked about the need for international cooperation in the war on terrorism. And one reason that subjecting U.S. citizens to duty not to aid foreign terrorist groups was important is because that international cooperation against terror, against targeting civilians, which is a clear violation of international law, was so important to the maintenance of the international community. And indeed, there are UN Security Council resolutions, Resolution 1267, Resolution 1373, that promote that kind of international cooperation. So we have prosecuted people, and I argue that has been an appropriate exercise of U.S. interest in this membership strand. Let me then take up, and I'll wrap up, the al-Awlaki case. And here I have a very different view than Professor Lee. It seems to me that if you believe, as the President has said, that we are engaged in an armed conflict against not only Al-Qaeda, but also associated groups like Al-Qaeda in the Arabian Peninsula, you get a different perspective on al-Awlaki's case. President Obama, in his speech in the spring, said that al-Awlaki had been an operational contributor to the plan to bring down a U.S. passenger plane above Detroit. That could have killed hundreds of Americans. That sounds like an armed conflict to me. It has all the indicia of intensity that we associate with an armed conflict. Al-Awlaki, the President said, also tried to destroy U.S. cargo planes. Destroying planes also seems like indicia of an armed conflict. If you're in an armed conflict, it's very difficult to inquire about the citizenship status of your targets. You can't check their papers. If they're going to attack you, you need some quicker, more decisive way to respond. Otherwise, your adversaries get the initiative. That guarantees you lose the armed conflict. Lincoln was aware of that. That's one reason he structured his application of the law of war in the way he did. Today we're aware of that as well. But at the same time, we have to pay heed to that affective strand. So you can't have a lower ranking official make a decision to target al-Awlaki in Yemen. You can't have the posture that Secretary Rumsfeld adopted with respect to that. Well, what, me bother about you as citizen? It shouldn't work that way. And here, in fact, the president made the decision to target al-Awlaki. There were also boards of lawyers, including then legal advisor to the State Department, Harold Coe, who were involved in that decision. In addition, what the State Department, Justice Department white paper on the subject said is that we have to, in that event, pursue the least harmful means that Tom addressed. So we have to at least ask the question, is capture feasible? We decided that capture wasn't feasible in Yemen for diplomatic and other reasons. At that point, we went ahead to target. So to me, that fulfills the affective strand of citizenship that I've been talking about. So to wrap up, the affective strand and the membership strand have been important since the founding era. They are even more relevant after 9/11. The combination, the balance between the two is still a work in progress.
Definitely a work in progress. That would be the tagline for the panel. We're going to move on to Bar Azmy, who's going to, again, stay in the present moment, I think, and talk about some of the more far-reaching consequences of the way he's constructed what Harold Coe, pick up where Peter left off, what Harold Coe has called the law of 9/11.
Thanks, Karen. So, yeah, I'm going to talk about a formal distinction between citizenship and alienage, and the point at which I think that distinction collapses as a practical matter, the point in which Muslim petitioners and plaintiffs enter the U.S. legal system. And we'll start with just a couple of points of departure, one heuristic and one historical. The heuristic point is to sort of hazard a rough definition of citizenship, which I would say, for purposes of argument, is roughly membership, legitimacy, and acceptance in a political community. And of course, there's a sort of technical notion of citizenship guaranteed by the U.S. Constitution based on birth, which I think is a remarkable development in the history of human rights. But I'm thinking about citizenship in a sort of a broader sense, in a sense in which Munir Ahmed, who's appearing later, has referenced through Hannah Arendt a right to have rights. The historical point of departure is the Supreme Court's decision in Korematsu, which was classically taught the proposition that the court wrongly accepted the claims of the U.S. military that race can serve as a proxy for suspicion, that all individuals of Japanese ancestry could be classified as suspicious and therefore detained without due process, regardless of any indicia of loyalty, including, say, citizenship. It's also sort of notable for blacks' defensive response to the charge of racism, of which he says, this is not motivated by racial animus. After all, we are at war with the Japanese Empire, so it has that sort of neutral cast in his view. So numerous commentators have observed the Korematsu decision stood sort of close in the Supreme Court's rearview mirror in assessing a series of post-9/11 sort of enemy combatant detention cases, as the court preserves some judicial role in evaluating claims of military necessity, and that's a view I largely agree with, given the importance of some of the separation of powers principles implied in cases like Hamdi and Boumediene. But I want to sort of question some of the triumphalism around those cases, at least as it relates to the question of citizenship, an intersection of the justice system and Muslim petitioners. We'll start with the sort of detention context, because before these cases like Rasul, cases in the DC Circuit held that Guantanamo detainees had no right to challenge the legality of their detention because in the DC Circuit's view, aliens held on foreign soil are entitled to no legal protections from the U.S. courts. Then in Hamdi versus Rumsfeld, of course, the U.S. Supreme Court holds that U.S. citizens are entitled, as a matter of due process, to challenge the legality of their detention. And then again, that principle gets arguably extended in cases like Rasul and Boumediene, which held that Guantanamo detainees, aliens, have statutory and then constitutional rights to challenge the legality of their detention, which were significant and positive developments, but ones in which I think have been largely or effectively neutered by a series of remarkable decisions by the DC Circuit Court of Appeals that has sort of limited meaningful judicial review of habeas claims by Guantanamo detainees, reflecting, no doubt, I think, the core view of a number of those individuals on the court that aliens held on foreign soil are entitled to no protections from U.S. courts. And so it might also consider, given lower court decisions in Padilla and Al-Mari, which have not been formally overruled by the Supreme Court, whether still U.S. citizens with suspected connections to terrorist groups who are apprehended on U.S. soil could be deprived of basic constitutional protections. After all, even the 2011 National Defense Authorization Act purported to authorize the detention of U.S. citizens apprehended on U.S. soil if there are suspected connections to terrorism. Or you can consider the recent revelations about the NYPD's intelligence division and their massive program of human mapping of Muslim communities in New York and New Jersey and elsewhere, and suspicionless surveillance of those communities and designation of certain mosques as terrorist enterprises. Again, without suspicion, and in the New Jersey case, the CCR have brought challenging legality of this practice. It's interesting that all of our plaintiffs have absolutely nothing in common, even though they're the subject of suspicionless surveillance, not economically, not demographically, not politically, not racially, except for their Muslim faith. And I think you can also see this sort of potential collapse of the citizenship foreigner distinction along the Muslim axis in the damages cases, in cases in which individuals have sought some kind of redress via Bivens for things like torture, extraordinary rendition, and targeted killing. And this is, there's not a sufficient time to fully explicate this doctrine, but you can start with, in the context of torture, for example, the DC Circuit's opinion in Rasul versus Myers, which held that government officials alleged to have engaged in torture of Guantanamo detainees are entitled to qualified immunity from suit because the right to be free from torture by foreigners held on foreign soil is not clearly established at the time, and with respect to the FTC claims at issue, torture is arguably within the scope of the military's employment. And so, not only did the court hold that it's sort of reasonable and even foreseeable for military officials to engage in torture and abuse, they also used the sort of, what I would say, dreadful in the Dred Scott sense of the term, claim that those detainees are not persons within the meaning of the Religious Freedom Restoration Act in order to bring RFRA claims. Then there's U.S. citizen Jose Padilla, who was apprehended on U.S. soil and brutally tortured. He's fared a little better in the courts. His case against John Yoo was dismissed on qualified immunity grounds in the Ninth Circuit, and his case against Rumsfeld was dismissed in the Fourth Circuit on similar grounds. And I think you could point to, as Peter has, Vance versus Rumsfeld, which is a case involving, I think, a Caucasian plaintiff, and I agree that adds some complexity to this otherwise obviously very complex analysis. But one response is that after a case like LeBron, that's the Fourth Circuit case dismissing his suit, we had already reached, as Ben Weisner artfully put it in his brief, the bottom of the slippery slope. And so, Vance wasn't surprising. You can also imagine that what's really going on is what Judge Karanis suggested in his opinion dismissing Maher Arar's suit for extraordinary rendition, which is that, there may sometimes be sort of valid individual claims, but we have to be careful about future litigants using U.S. courts to extract damages from U.S. officials, whether it's Maher Arar, Masri, or anyone else. And so it's quite possible that Judge Easterbrook in Vance has the same considerations and worries in mind. You can consider our targeted killing policy, and here I Paulsen of Thomas said, I wouldn't call it a case, your case, I would call it a CCR case because we're co-counsel on the case. That challenges the targeted killing of 3 United States citizens by drone strike, as a number of people have said. The district court, in a previous iteration of this litigation, dismissed claims by injunctive claims by Mr. Al-Awlah's father to ensure some sort of due process, some procedures before he was put on a kill list, a case that was dismissed on a variety of judicial doctrines. And then after his assassination and the killing of 2 other individuals, including his 60-year-old son, we brought suit. And I think one can expect it would be hard, given the doctrine that had been previously developed, for him and his family to get remediation or meaningful limits on the president's killing authority. They're sort of lumped together as ordinary soldiers, not entitled to basic constitutional protections. And I think as courts deny elementary constitutional and human rights protections to citizens and aliens alike, there also seems to have been a reluctance to acknowledge some systematic aspects of abuses of certain populations. Military invasions of Muslim countries, surveillance and harassment and intimidation of innocent Muslim communities, torture and abuse of swaths of Muslim detainees, and whatever sort of isolated excesses that we may be able to acknowledge. Ultimately, it feels like we cast these problems in as the Foreign Defense Secretary did as the work of a few bad apples. There's no way attributable to sort of policymakers or systematic bias or discrimination. And for these purposes, and to conclude, I want to consider the relationship of citizen racism embedded in Korematsu via the Ashcroft versus Iqbal case. And as I think most people know, the court held in that case that it was implausible to believe that high-level government officials such as Attorney General Ashcroft and FBI Director Mueller themselves maintained any religious animus towards the Muslim plaintiffs, and who alleged that they alone were subject to a particular discriminatory policy of holding them unlawfully, even though they only had committed civil immigration violations. The idea that the claim involved religious discrimination, I wouldn't think is necessarily implausible. It seems contestable enough to me that it should go to a jury, but it seems to me that the court vindicated Justice Ashcroft's worldview in a way similar to the way that Justice Black vindicated General DeWitt's worldview in Korematsu. It was not racial animus that motivated this policy that treated Muslims distinctively, just like it was not racial animus that presumptively assumed the dangerousness of Japanese people. We did this, Justice Kennedy explained, to exclusively Muslim detainees because, well, of course, we were attacked on 9/11 by Muslims. But that sounds a lot like what Justice Black had said about the claim of racial animus in Fordham. We didn't do this because of racial antagonism. We did this because we were attacked by the Japanese Empire. So this suggests to me that we're sort of still struggling with the powerful legacy and logic of Fordham and Paulsen judicial deliberations. And maybe it's not that far from the judiciary rearview mirror. And so, given some of the still limited evidence I've laid out, I think it bears asking whether individuals who retain formal citizenship here, in fact, members of an accepted and validated and protected community. They may be, by virtue of their association with a foreign religion and a foreign land, have no right to have rights.
It certainly gives you food for thought. Think about the power of the state, but the other thing it gives you food for thought about, as I listen to all of you, is eventually the character of a nation announces itself over time. And so I guess Peter was right. This is a work in progress. But David Cole has been thinking about how it could have looked differently. Somebody used the word creative legal thinking earlier today. And I think how this could have looked differently depending on the United States' attitude towards non-citizens. And so,
thanks. I first want to thank Karen and the law review staff for putting this tremendous symposium together. So there have been many tremendous symposiums under Karen's tutelage, and I'm always happy to be part of them. I want to ask I want to focus a little less on citizens and a little more on immigrants, and ask how our response to 9/11 might have looked differently if we had not been permitted to discriminate against foreign nationals in virtually all of our most extreme measures. And I go back to 1919, when, in response to a series of terrorist bombings, the FBI, under the leadership of the Justice Department, under the leadership of J. Edgar Hoover, rounded up thousands of foreign nationals using immigration authority as an excuse, none of whom were responsible for the bombings. And in a book about that era by a man who had been in the government at the time, Louis Post, he wrote that the force of the delirium caused by the bombings turned in the direction of a deportation crusade with all the spontaneity of water seeking out the course of least resistance. What he meant by that, of course, was that the reason we rounded up immigrants was not because they were the bombers, but because they were immigrants, because we could target them. They were the course of least resistance. And so, in a sense, I want to ask, what if we had blocked the course of least resistance after 9/11? Because we didn't block it, we pursued it, and that made it easy for the government to sort of strike the balance and justify the particular balances that it struck to the people by saying to the people, look, we need to protect your security. There's tough questions about what of your liberties you might want to give up in the name of your security, but we have a better deal for you. We will sacrifice their liberty for your security. And there's always a risk, I think, in times of stress that that the polity will discount the values of liberty and overcount the interests of security. But when the polity is asked to weigh their own security against somebody else's liberty, somebody who's treated as categorically different so that taking away their liberty doesn't implicate your liberty, well then it's extremely likely that there will be overreaction. And so what we saw was that Guantanamo was reserved to foreign nationals, and indeed when they found out that Hamdi was originally at Guantanamo, but as soon as they discovered that he was an American citizen, they quickly took him off of Guantanamo. We couldn't justify Guantanamo if it was used for U.S. citizens. The military tribunals have always been limited to U.S. citizens, as were rendition, enhanced interrogation, and almost all of the preventive detention conducted here in the wake of 9/11 in the United States. Over 5,000 foreign nationals detained in anti-terrorism initiatives in the first 2 years after 9/11 by the government's count. Again, all foreign nationals, none of them linked to 9/11. We're not the only country to respond this way. The UK, in the wake of 9/11, authorized the preventive detention of suspected terrorists who were foreign nationals who were under orders of deportation but couldn't be deported because of concerns about torture if they were sent back to their country of origin. The UK's parliament authorized their preventive detention, the notion being these are dangerous people, we can't deport them, we can detain them. But that authority was challenged, ultimately went to the law lords, the UK Supreme Court, and resulted in what I think is the single most important decision in the post-9/11 era on the question of national security and rights. And that decision by the law lords said to detain somebody without trial because he's dangerous is a deprivation of liberty under the European Convention on Human Rights. The UK says we need to do it because of national security. We understand that's a justification. Sometimes that will be an appropriate justification, but you have to show that it's necessary in a democratic society under European Convention law to justify it. And they said it's not necessary in a democratic society to detain foreign nationals who are suspected terrorists if you're not detaining British nationals who are suspected terrorists. And the court reasoned whether a person is a citizen of Britain or a citizen of another country, if they're a suspected terrorist, they pose the same national security threat to the country. And again, whether you are a foreign national or a British national, you have the same interest in not being locked up arbitrarily. So the interests on both sides are the same, and yet Parliament chose to single out one group, foreign nationals, and impose this on them and not others. That's impermissible under the European Convention. And that went up to the European Court of Human Rights, which affirmed, so that within the context of Europe, responding to terrorism does not permit of this distinction that we so reflexively adopt between the citizen on the one hand and the foreign national on the other. So what if the Belmarsh decision had been decided here in the United States? What if our government, like the UK's government, was obligated to treat foreign nationals and citizens alike, except where there are good reasons for treating them differently? Well, I think it's an interesting thought experiment. Guantanamo. Would Guantanamo have been possible if U.S. citizens alleged to be associated with al-Qaeda could be held there indefinitely without trial? It is true that the Bush administration detained 2 so-called enemy combatant U.S. citizens, but both of those cases caused much more consternation among the public than any of the Guantanamo detentions ever have. And they ultimately released Mr. Hamdi and took the first U.S. citizen before, when required to give him a hearing, they instead just let him go. And with respect to Mr. Padilla, they put him into a criminal proceeding to avoid adjudication. And since then, there have been no enemy combatant detentions of U.S. citizens. The recent fight and concern over the NDAA is all about its authority to detain U.S. citizens, not its authority to detain foreign nationals. So again, if we had to apply the same standard to citizens and foreign nationals, I think we would see a very different Guantanamo. Military tribunals, from day one, from President Bush's presidential order in November of 2001 until the Military Commissions Act of 2009 enacted by Congress, the military tribunals, a form of second-class justice, have been limited to foreign nationals. Why? Not for any legal reason, but for the political reason that were they applicable to citizens, there would be much greater concern, and we would be much more difficult to have a second-class system of justice. Non-military preventive detention, the 5,000 who I mentioned before who were detained in the United States, all foreign nationals, without any showing that they were dangerous or a flight risk. That practice was challenged, and it was challenged on the basis of a Supreme Court decision involving a demonstrably dangerous foreign national who had been ordered deported but could not be deported because of concerns about torture. And the Supreme Court said the only legitimate purpose of immigration detention is to effectuate deportation where a person is a flight risk or dangerous. And even where the person is flight risk or dangerous, if he can't effectuate deportation within 6 months, he's presumptively must be released. Well, with the Center for Constitutional Rights, we brought a lawsuit on behalf of many foreign nationals who were detained here without any showing of dangerousness or flight risk. And the Second Circuit flipped the Zadvydas decision around and said, even where there's no showing that an individual is dangerous, no showing that an individual is a flight risk, if he's an immigrant, he can be presumptively detained for 6 months. Can anybody imagine a U.S. court saying it is permissible to detain a U.S. citizen who has not been shown to be dangerous, not been shown to be a flight risk, for 6 months? It's unthinkable, and yet it was that was the ruling of the Second Circuit. Enhanced interrogation. Can we imagine even Dick Cheney authorizing waterboarding of U.S. citizens? Well, maybe we can. Legally, a key move in justifying the enhanced interrogation regime was to say it's okay to do it to them because they're foreign nationals held outside the United States, and therefore they don't have the protection of the international treaty barring cruel, inhuman, and degrading treatment. Politically, I think it's very, very difficult to imagine the United States government authorizing waterboarding of its own citizens under any circumstance. NSA surveillance. Edward Snowden revealed 2 principal programs. One, the Section 15 metadata program that gathers all of the data on all of our phone and text communications, the emphasis being our. And then the PRISM program, which is directed at them, at foreign nationals, international communications. Most of the concern that's been articulated has been focused on 215 because it's our metadata. The concern about the PRISM program is not that we're listening in on hundreds of millions of foreign nationals' phone calls and email traffic and Skype and the like. But we might be incidentally capturing the communications of U.S. citizens who are talking to those foreign nationals. What if the rule were that you must protect the foreign nationals' privacy in the same way that we insist on protecting the U.S. citizens' privacy? And then drones. Considered a very different reaction to drone killing of Anwar al-Awlaki, the U.S. citizen, on the one hand, and the several thousand Pakistani, Yemeni, and Somalian victims of drones. Rand Paul held a filibuster. It was not about any of the several thousand. It was about the possibility that an American citizen on U.S. soil might be killed by a drone. My favorite poll on the drone program was reported in the New Yorker by Andy Borowitz, and he reported that this poll found that 95% of the American people were opposed to the use of a drone to kill themselves. 5% weren't sure or didn't know. And in the story, he says that Jay Carney, the White House press secretary, responded by saying, "Yeah, we get that. We get it that Americans don't want to be killed by drones. But I think they have a very different reaction if we're killing somebody else with a drone. So I think the entirety of our national security response has been framed by this assumption that it is appropriate to distinguish between the foreign national and the citizen, and to treat the foreign national as not deserving of basic rights to privacy, to liberty, to freedom from torture and cruelty, and indeed to life. I think if we had to follow the guidance of the law lords and the European Court of Human Rights, we would still have military preventive detention, we would still have drone killing, we would still have NSA surveillance, and we would still have interrogation. But in each instance, I think, the rules that govern them would be more tightly constrained, political checks would be much more significant, abuse would be much less widespread, and oversight would be much more robust. The Belmarsh decision did not say, and I'm not saying that there are no bases for distinguishing between foreign nationals and U.S. citizens. It said that you have to give a reason. You can't just assume that there's a justification for treating them differently without giving a good reason. Like many of us assumed that it was just to deny same-sex couples marriage without giving a reason. And then lo and behold, when we actually had to give a reason, no one can come up with a good reason. The European Convention on Human Rights is, of course, a human rights treaty. Human rights don't turn on a passport. They don't turn on citizenship. The right to have rights doesn't stem from citizenship. Under the human rights conception, it stems from our common humanity. Our founding document is a domestic constitution, but it doesn't draw distinctions between foreign nationals and citizens except for voting and elective office. But in our all too parochial way, we have simply assumed that foreign nationals and citizens are not entitled to the same rights. That assumption makes it much easier for us to, quote unquote, strike the balance. But in my view, it's been the source of all too much error, all too much abuse, and all too much suffering.
We're going to have questions, so get your questions ready. Just a follow-up on that. Is there a way to argue that the not making the distinction, just across-the-board distinction, but thinking about it, which is basically what you said, would be better for Americans?
No. Except in the sense that it would be better for Americans in the sense that I think we would have a more morally legitimate and appropriately balanced response to these types of threats. So in that sense, it would be better for Americans. But I do think that one of the reasons this distinction is so often adopted is because it's easy. And it's easy because we get something out of it. We get to adopt security measures that we don't have to pay for. And you can go down the line in the post-9/11 era, the only times where there's one exception, but with one exception, the only time where there's been a political response to a national security measure being too overreaching has been when it implicates Americans. And the only exception to that, and for this I give John McCain a lot of credit, is the McCain Amendment, which insisted that the cruel and human degrading treatment prohibition applies to every person, regardless of what passport they have and where they're being from.
Of course, you could say that the way terrorism suspects who are American citizens are treated is not really protecting their rights.
Well, no, yes. I mean,
Just saying, for your category.
There are spillover effects.
Yeah.
Yes,
That's not going to be better.
and actually, one of the arguments of my Enemy Aliens book was that we often start down the road by distinguishing between citizens and foreign nationals. But what typically has happened is the government has grown comfortable with these tools that are used against foreign nationals, and so then over time they get expanded, and ultimately get expanded to citizens, and it's only when they get extended to enough citizens that there's a kind of pushback. So yeah, I think it would encourage more reasoned response to the stress posed by national security crises. That's for sure.
Okay, time for your questions.
Hi, this is Fordham. It seems to me that you think that that we've been creating this artificial distinction between citizens and non-citizens, and that we've been looking here being sort of this fundamental notion of justice. However, I'm interested to see what you would think about, I think if you look at the Constitution, we do talk about U.S. citizens and we talk about foreigners, and I think that, is aside from this sort of universal notion of justice, would you point to any specific place in the Constitution or another sort of document from our founding which says that there's no difference between the two? Because I think you could argue that there is sort of fundamental difference between a U.S. citizen and a non-citizen, which is why there are accorded different levels of sort of procedural rights.
Yeah, and I have addressed that in Enemy Aliens and in an article called "Do Foreign Nationals Have the Same Rights as Citizens?" And I think as a constitutional matter, and I think if you look at the Constitution, it does draw a distinction between citizens and foreign nationals, but they're very limited. The distinctions involve voting and running for elective office. They do not involve criminal trial. They do not involve due process. They do not, those are rights of people. They're rights of the accused. They're not rights of citizens. So, and so if you're going to give the words of the Constitution the meaning, their meaning, one would presume that where they say citizens, they mean citizens, but where they say people or persons, they understand that people without passports are still people. The people without passports are still persons. So I think there's actually quite a bit of support in the document itself. And indeed, some of this we don't question, nobody questions, right? Every person who is put on in a criminal trial has all of, whether they're foreign national or citizen, whether they're an illegal alien or a permanent resident or born here, they have all the same rights of confrontation, right to counsel, right to object to illegally obtained evidence, right to object about coerced confessions. None of those are treated differently. So I think there's very strong support in our Constitution. We have, where there's not very much law, and with what law there is not very good, is with respect to the rights of foreign nationals outside of our borders when we assert our coercive authority against them. And there, Andrew Kent has written very well on this, taking a different point of view, but I'm of the view of Professor Newman at Harvard and many others, that when the United States asserts its coercive authority against human beings, the Constitution should presumptively apply. Now, in certain circumstances, the Constitution might not require very much, and in war, it's obviously often going to be a different situation, but we shouldn't just assume, as we all too often do, both politically and legally, that, well, it's citizens who have the right to have rights. No, it's human beings who have the right to have rights.
More questions? Carol?
I think this might be for the historical imaginers, but generally for journal. It seems that when we talk about the nature of citizenship, it starts to distinguish the difference between citizenship and personhood. That in the Constitution, when it says,
nice small question. Just for me. It's actually a good question. I think in today's globalized world, will the definition of citizenship change? Anybody want to take a stab at it? Peter?
That is a very ambitious question, but I think it's certainly one we ought to ask. I do think in many respects we're citizens of the world. I think the founders contemplated that. So they're very aware of international scholars like Patel, and they saw themselves in that light. In some ways, they saw themselves far less parochially than we see ourselves today. So I think that's a very important element. And frankly, we can't ignore the rest of the world, although I have a fair amount of disagreements with decisions of European Union tribunals, interpreting the European Convention on Human Rights, because we act with our allies who are subject to the decisions of EU tribunals. We cannot ignore those decisions. We have to engage with them. And you look at Boumediene, a decision which I think is right, as a decision which says that even outside of the confines of the territory of the United States, if we exert jurisdiction and control, then we have at least certain rights that we have to accord to detainees, or at least they have some access to our courts in order to promote the separation of powers scheme that Justice Kennedy said in Boumediene really is the first and most important guarantee of liberty.
Can I add? Peter Spiro is actually in the audience. He's sort of, in terms of what the legal concept of citizenship means, and he's sort of the expert on it. But, for example, it used to be that under international law, for example, the idea of how to define citizenship was considered purely discretionary to the country, right? But now norms are developing that say essentially that if you're the second generation of someone who's born there, you can't deny citizenship or something like that, right? So it is changing, right? I mean, it's just a very long process, and because it's so essentially linked to territorial sovereignty, I think any process would be very incremental.
Ready? Have a question?
So first of all, David, it will probably come as no surprise that I agree with almost every word you said. So I wanted to support your insights even further with a comparative law point, which is even before the law lords and the Strasbourg decision, the essential way that most countries had fought terrorism, and some countries had fought terrorism that was quite, had hit a certain level, including the United Kingdom of Northern Ireland, was not the United States manner, but rather by creating an emergency law system, which was to say that for both citizens and non-citizens, those who were suspected of terrorist offenses would be funneled not into the normal criminal courts, but to essentially a junior varsity judicial system. And that's not true of just the United Kingdom. It's actually true of, as you know, most of the former British colonies, and indeed, a lot of the continental nations now. And in fact, in Ireland, as only they could say, ordinary decent criminals got full due process protections, but the terrorists got the junior varsity criminal justice protections. But the point is that it was at least a criminal justice system, unlike the effective black hole that we submit non-citizens to. And that, as I say, is something that even predates the opinions you talked about, which I think, and the same then phenomenon exists. Why does the floor only drop so far in Europe and other places? It's precisely because the emergency system doesn't distinguish between citizens and non-citizens. And so the dynamic you're talking about, the thought experiment you were talking about, I think has actually been run in these other countries. And the irony, at least for me, is I spent 20, 30 years fighting against the diminutions of due process rights in emergency law systems, never thinking that that would be the desirable result, by comparison to what we were doing, but I guess it is.
Well, I think there's a way in which, it's a great point, and I think what you see where you can't distinguish between the insider and the outsider are often our sort of informal distinctions between the insider and the outsider. It was the Irish, not the British, who were being subjected to most of this. But and there's certainly no guarantee that there won't be an overreaction, that an emergency measure won't be off kilter. But it makes it more likely that over time there will be continuing pressure to right the balance. And so with the on the preventive detention measures, first they say preventive detention, unlimited. That's struck down. You have to treat British nationals and foreign nationals the same. They don't abandon the concept, but they make it more limited, controlled. There's a kind of house arrest. Then there's opposition to that, which then gets applied to British nationals as well as foreign nationals. There's opposition to that, and they water it down further to something called temporary protective interim measures, which are even less extreme and those too have been under a lot of scrutiny and a lot of criticism. And again, the Brits can imagine themselves being subject.
Well, two concluding thoughts. The first is that yesterday the new head of the FBI, first new head since 9/11, Jim Comey, said that he thought that the most important thing the FBI had to pay attention to going forward was terrorism. But he added that it wasn't just international terrorism anymore, it was domestic terrorism. So I think these issues are going to be extremely important going forward. They're not going away. And the second thing is that, just a note of interest, is that it's really interesting how the discussion of citizenship plays out in all of these remarks. Because it sounds like a tangible thing, like there's only so much citizenship to go around. So we have to make sure that we hoard it and keep it only for, a privileged group. And it's a very odd notion, and it may not sound odd to us now, but I think in the future, that idea that, that these are the crown jewels, and only some people can, that's what you guys have all made me think. So thank you for being here, and thank you.